Hey, welcome everybody. Welcome to the Law Self-Defense live stream for January 14th, 2022. Hopefully everybody can hear me okay. I'll flip on the comments here. All right, folks. Thanks to all of you for joining me. Can't tell you how much I appreciate it. I know this was short notice for everybody, but we heard this news about State's Attorney Marilyn Mosby yesterday afternoon. And this morning, of course, we felt obliged to report on it because we have some prior life experience covering Marilyn Mosby. And frankly, it's hard to imagine anything bad happening to her that would not be well deserved in the sense of karma, especially if it's actually of her own making, which appears to be the case with this federal indictment announced yesterday against Marilyn Mosby. I do caution, we're still new to these live streams. They're a little bit of kind of technology demonstrator learning opportunities for us. We'll be doing a little screen sharing of various documents and such to the extent I can, that I'm able to pull that off. I'm certainly am not at Nick Ricardo levels of live streaming, but hoping to get there as quickly as possible. So over the course of the show today, and I have no idea how long this will go, and it'll go, I guess, until I run out of things to talk about, but we'll have occasional promotions of books and things like that, memberships. We'll mention those. We will strive to answer all the super chat questions that are posed during the show. So if you have a question you'd like me to address, it need not be related to Marilyn Mosby or anything in particular, and any question you might have about use of force law, cases in the news, that kind of thing, feel free to post them up in the super chat, and I will strive to get to all of those before the end of the show today, whenever the end of the show might be. And of course, we have Emily on board as our moderator again today. So please behave yourselves accordingly. This is, again, not the Rakaida comments stream. So I appreciate that very much. And yes, Emily continues to do very, very well. So thank you all for the kind thoughts and prayers. That's much appreciated. So what was the interesting news from yesterday? Well, it had to do with Maryland State's Attorney for Baltimore, Marilyn Mosby. Let me clean up my desktop a little bit here, pull open the Marilyn Mosby folder, and I'll see if I can share the federal grand jury indictment that was handed down yesterday. Let's see how this works. I'll move this around. Share screen. Okay, so we should now be looking at, see if I can adjust this a little bit. I guess we don't really need the thumbnails. But it does want to get rid of the thumbnails for me. Hide sidebar. There we go. So this is the document handed down yesterday, January 13th. It's a federal grand jury indictment of Marilyn Mosby. Marilyn Mosby is the state's attorney in Maryland for the city of Baltimore. Kind of a controversial figure. Came into office right about, I believe it was 2015, right just before the Freddie Gray event occurred. We'll be talking about Freddie Gray for some people. Yeah. So anyway, Marilyn Mosby. First, we'll talk about the indictment, and then we'll take a walk through memory lane with some of my recollections. I reported on the Freddie Gray trials in great detail, as you may be familiar from my coverage of more recent cases like Arbery and Potter and Rittenhouse. We made the same kind of effort for all of the police officers who were tried in the Freddie Gray case. And it was about as horrifying an experience as you would imagine from politically motivated prosecutions of police officers against whom there was literally zero evidence of demonstrable misconduct, but whom were nevertheless charged with crimes as serious as murder and could have expected to have spent the rest of their lives in prison if convicted on these nonsense charges brought by Mosby. including, by the way, some of the officers were African American, some of the officers were female. So it was not just white officers who were subject to this persecution by State's Attorney Marilyn Mosby, a persecution carried out purely for political purposes. And if you're wondering if Marilyn Mosby had received financial support from Mr. Soros, the answer would be yes. That's how she got elected in the first place, and then reelected a second time. She's supposed to be running for reelection again, I believe, this year. She's still planning to run for that office for a third time, and she might well win, even despite this grand jury indictment. But it appears what Marilyn Mosby was indicted for was making various false statements on financial forms for a variety of purposes. Here we have count one. It states perjury, COVID-19 financial hardship withdrawal. So apparently she was permitted under the COVID rules in effect. If you had, say, funds in a retirement account, normally you would have to pay a substantial penalty for early withdrawal of those funds. Except under COVID, you were permitted to make an early withdrawal without penalty if you were suffering certain specific enumerated financial hardships under COVID, like loss of a job or loss of income and so forth. And she applied for this early withdrawal benefit under the COVID rules, apparently for the purpose of doing stuff like buying vacation homes in Florida. She had not, in fact, suffered any of the required hardships, but she lied on the form. This is a federal form, therefore it's federal perjury to lie on these financial forms, and that's what she has been declared to have done. In particular, she, as we see here in the indictment document that I'm sharing on the screen, she checked off the box that says, I have experienced adverse financial consequences stemming from such virus or disease as a result of being quarantined, furloughed, laid off, reduced hours, being unable to work due to lack of childcare, closing or reduction of hours of a business I own or operate. None of that happened. So she experienced no adverse financial consequences, none of those listed. She was making $250,000 a year as state's attorney. She was being paid regularly on time, that salary, and therefore she arguably committed perjury, federal perjury, in falsifying this application for non-penalty early withdrawal under these COVID rules. The next count is that she lied on mortgage applications. I believe this was again for these Florida vacation properties. She bought two of them with her husband. We'll talk more about her husband in a moment. She failed to tell the mortgage company, which she was obliged to do when they asked her about it. She failed to inform them about a substantial federal tax lien on their property. Turns out she was a tax deadbeat as well. She owed the IRS almost, a large sum of money. Here we see it's $46,000 plus for 2014, $17,000 plus for 2015. So that's a total of what, 40, 50, over $60,000 that they were just deadbeat on. And to the point where the IRS put a lien on them, which means it's not like you were short and they told you and you paid them the money. You were short and they told you, and then you didn't pay them the money. That's when they put a lien on your property. They try to just get you to write a check first. It's when you refuse to make good on your tax debt that the lien comes into play. So here's one of the vacation homes, a Kissimmee vacation home, $500,000 for that vacation home. And then there was, let's see if they list the other one here, blah, 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 blah. Maybe I already passed it. There was another one on one of the keys, Long Beach Key, I believe. It doesn't really matter. But by failing to disclose this federal tax lien when asked, again, she committed perjury on a mortgage application too. Of course, anything to do with banks, for the most part, is going to be federal in nature. So another federal perjury count. And let's get to the third charge. Count 3. This is another hardship withdrawal. So I'm not sure how this differentiates from count 1. Maybe it looks like she just did it twice. Maybe she did it in successive years. But again, she made that same false statement on the application for the non-penalty early withdrawal based on a false claim of COVID hardships. So she just lied on these documents, lying on these documents that they're all noted. You're signing them under penalty of perjury. And I have not looked myself. I've been told that each of these is good for 10 years in prison that could be served consecutively, meaning 30 years in prison. And folks, federal prison time is real prison time. There's almost no allowance made for good behavior, for example. So it's not like in many state systems where you might be sentenced to uh, 30 years and do a third of that based on good behavior, right? Have the sentence mitigated, discounted for good behavior. The feds don't do that. They do a little bit of it, but it's less. It's like less than 10% of the sentence time, so it's very modest. So when you're sentenced to federal time, you're going for essentially the entire sentence. Yeah, it's noteworty that of course, she's from Blue State, Maryland, and escaped to the purported Nazi hellhole that is Florida with her $500,000 vacation homes. It's weird, huh? I mean, she could have gone to California, I guess, or some other blue state, but nope. Florida was attractive for some reason. I wonder why. So that's what she's been charged with. It is curious. I mean, of course, Maryland is as blue can be. She's a part of the state political machine. She's well established there now. She's been elected state's prosecutor for Baltimore twice. Probably would win a third time if she ran a third time, which she says she will do. So she's pretty solidly ensconced. Her husband, I said we would talk more about him as well. I'm not sure what his current status is. But at the time of the Freddie Gray trials, 2015, 2016, he was a local Baltimore politician himself. In fact, he's the one that triggered the police sweep that would end up in Freddie Gray's arrest and ultimately Freddie Gray's demise. Little reported in the Baltimore media at the time. And I think an incentive for why Mosby went so over the top in prosecuting these officers, but we'll come back to that again in a moment. So these two are both political operatives within that Democrat blue machine in Baltimore. So to expect that that political machine would hold their own accountable may seem unlikely. And of course, the federal government indictment is not Baltimore, but it is Biden. I mean, this is Biden's Department of Justice, not exactly Trump town. So why would they be willing to pursue Marilyn Mosby in this way? Lots of people lie on these forms and are not indicted by the federal government over it. I can only speculate. Of course, I'm not inside Democrat politics. Usually, when this kind of thing happens, it's like what happened with Governor Cuomo in New York. Usually, it's because the person has pissed off the wrong people. They've decided that the juice is not worth the squeeze for that individual. They have someone identified that's, from a normal person's perspective, even worse to put in to that slot. So they're willing to sacrifice their political operative currently in place, get rid of them because something went wrong in that relationship, and they're just going to replace that person with somebody even worse. So if Marilyn Mosby were to be convicted and sent to federal prison, I assure you the next state's attorney in Baltimore is unlikely to be any better from any moral or legal sense than is Marilyn Mosby. That's not how these things tend to work out. But I suppose we'll see what happens if she does, in fact, get convicted on this stuff. If she really has pissed off the wrong people, then this thing may have legs. Normally, I would say, it's not going to happen. She won't get convicted. But normally, I would say she wouldn't have been indicted in the first place. So the fact that the indictment happened, it's not a good sign for Marilyn Mosby, especially on charges that are, in contrast to the charges she brought against the police officers in the Freddie Gray case. These charges are easy to prove. I mean, these documents are, they're physical documents. She signed them. She checked the boxes. She made the representations. There's clear evidence of these criminal acts. So a defense here would be pretty difficult. In contrast, when she was prosecuting police officers over the death of Freddie Gray, she had no evidence, none, of affirmative misconduct by any of those officers. So let's dive into that. What was Freddie Gray all about? And let me see if it's possible for me to pull up some of the stuff I did for legal insurrection when I was writing about the Freddie Gray cases. So, yeah. Here's one. See if I can pull this up. Well, legal insurrection runs a lot of ads on their content. So this was one. So after the Freddie Gray trials were over, the federal officers actually tried to sue Baltimore State Attorney Marilyn Mosby in federal court. Unfortunately for them, prosecutors have effectively unlimited discretion in their jobs and effectively unlimited qualified immunity from prosecution for decisions made in the course of their normal jobs. So even though Mosby's conduct was truly egregious, monstrous, really, there was a possibility that she might have been subject to civil liability for her decisions because they were so over the top outrageous. For example, she claimed that the charges she brought against the officers were based on an independent investigation that she had one of the prosecutor's office's investigators run in secret. But when that investigator was put under oath, he said, I don't know what she's talking about. There was no alternative secret parallel investigation by the Mosby office. So she just completely fabricated having any basis for these criminal charges against these 6 officers. You'd think that would be enough to pierce qualified immunity. Ultimately, however, the courts decided, nope, she's immune from civil suit even under those circumstances. So let's dive into what actually happened with Freddie Gray. So Freddie Gray was, and I'm doing most of this from memory, folks. I don't think I'll have any substantive facts wrong. I covered these trials and the pretrial proceedings, every minute of them, but it was 6-7 years ago at this point. I don't, for example, off the top of my head, remember the names of the 6 officers. I would have to look that up, but it doesn't really matter what their names are. But if I do make a small error in fact, please don't hold it against me. It doesn't change the analysis or the overall view of what happened. So Freddie Gray was apparently a low-level street corner drug dealer. There's a few of those in Baltimore. In fact, in this one block, there was a ton of them. It was completely out of control. It was an open-air drug marketplace, which again is not uncommon in Baltimore. But some of the residents were complaining to their local city politician. That city politician happened to be the husband of Marilyn Mosby. So he went to his wife, who was a recently elected state's attorney for Baltimore, and said, hey, honey, is there anything maybe you could do? Ask the cops to maybe do a sweep of this block. I'm getting a lot of complaints from my constituents about all the open drug dealing happening. Maybe the cops could come in, bring a dozen or 2 dozen officers in, do a quick sweep of the block, pick up a bunch of people, clean things up for a bit, so I can go back to my constituents and say, hey, look, you complained. I represent you at the city level. I got this done. Vote for me again, right? That kind of thing. And Marilyn Mosby said, sure, sweetie, I'd be happy to ask the police to do that. Well, when the state's attorney asks you if you can assign a couple dozen officers to do a sweep of a open air drug market, and you're at the Baltimore Police Department, you go, yes, ma'am, we can do that for you. And so that's what they did. The police came in numbers, swept through the block. And of course, the moment they show up, people like Freddie Gray, who are actively engaged in the conduct of street corner drug dealing, say, uh-oh, there's the coppers, time to go. And he starts running. And the police see him running, which creates at least a reasonable suspicion that he's up to no good. They chase him, they stop him, and they end up arresting him. I don't believe there was a drug charge. I honestly don't recall, but I definitely remember he was arrested on a knife charge. So there's a Baltimore city ordinance that prohibits the possession of what they call assisted opening knives. An assisted opening knife would be something that, like what I carry, it's a little spring-loaded device. It's not a switchblade. You still have to do more than just press a button, but it has a little spring that helps the blade open like that. This is a junky knife I use for opening cardboard boxes, so it doesn't work as smoothly as it used to, but that's the idea. Little flick like that and the knife opens, as opposed to having, if you ever carried like an old style buck knife where you have the little thumb groove and you got to kind of peel the knife open like this and hold it in two hands, that kind of thing. Well, they're illegal. Assisted opening knives are illegal in the city of Baltimore. And in fact, Mosby's office had prosecuted hundreds and hundreds of cases for illegal possession of assisted opening knives. So this is very normal. The police were not, creating a pretext for an arrest. This was a common basis for arrest in Baltimore. Freddie Gray had that assisted opening knife, so they made the arrest on that purpose. And they had to chase Freddie down, and they tackled him to the ground. He was non-compliant with arrest, so there was a little bit of a struggle there. They get him handcuffed, and they bring him over to a van. He's resisting getting into a van. This is what would have been called, sorry for the pejorative folks, but in my youth, it would have been called the paddy wagon. So they're going to throw him in the back of this police van. Basically, it's a metal van structure with bench seats running forward to back. There's actually two separate compartments, a right and a left, again, with the benches running forward and back. And they put Freddie Gray on one of those benches. And he's fine when he goes into the van. There's no injury. There's no evidence that the officers used any unlawful force against him. There's no evidence that those officers used any force against his neck in particular. And it would be his neck injury that ultimately would kill him. Yeah, that is a Kershaw. I think it's a Kershaw, right? Yeah, Kershaw. I love these knives. I buy a bunch of them. They're very inexpensive. They're sharp, at least when new. They do wear out fairly quickly. I think they're only 30 or 40 bucks. They're not expensive. And when you get to the airport and you discover you still have it in your pocket, you don't feel so bad just throwing it in the garbage can so you can board your flight. I've owned expensive knives, and man, it's hard to separate with those at the airport. So Kershaw's I don't really worry about. And I just have a box of them here in the office. So I just grab a new one. But yeah, I like those Kershaws a lot. So Freddie Gray's put in the back of the van. He's in perfectly fine health, maybe a little bruising from having resisted arrest, but no injury to his neck, no use of force against his neck. The van drives a short distance. I believe it had to stop to pick up another arrested suspect. But in any case, the van travels a short distance, stops. They open up the back of the van, and Freddie Gray has essentially a broken neck. So maybe not completely broken, but so badly injured his neck that he would receive medical care for it in an operation, but he would die about a week later because of either the neck injury itself or complications resulting from treating the neck injury. So Freddie Gray is dead of a broken neck. Well, the question is, how'd that happen? And of course, now there's a media narrative that can be spun, right? And a political narrative that can be spun. Freddie Gray had his neck broken in police custody. Well, if that's all you hear, you would think that the police, it was a Rodney King thing. They beat him with nightsticks until they broke his neck. The media doesn't make any effort to tell both sides of the story because that doesn't get them clicks. So all they report is that Freddie Gray died of a broken neck while in police custody. Suggests that the police must have done something bad to him. And so there's the usual kind of political outrage. By the way, the police that were involved in his arrest were multi-gender, multiracial. There were white officers, black officers, male officers, female officers. I think there may have been an Asian officer. I'm not sure I recall that correctly. But there was a very diverse group of police officers involved in Freddie Gray's arrest. And it was on video. So we have surveillance video of the arrest, of him being put into the van. He clearly does not have a broken or injured neck going into the van. He definitely had a broken neck when they get him out of the van. So what the heck happened? Well, when the medical examiner takes a look at Freddie Gray's body, she characterizes the neck injury as akin to a shallow diving injury. So you can imagine what that's like. Someone dives into a pool. They underestimate how shallow it is. They end up striking their head on the bottom of the pool. You suffer a neck injury, right? Certainly one that can kill you. What appears, a reasonable hypothesis for what happened to Freddie Gray is he was put in the van. The van was traveling. Freddie Gray was handcuffed. He had his hands cuffed behind his back. He may have stood up, you can't really stand up in the van. You have to be kind of crouched over, but stood up off the bench, facing towards the front of the van. And anyone who's ever ridden in a moving vehicle like a subway or a bus where they have poles and straps to hold on to, they have those things because if the vehicle changes velocity, changes direction, you'll fall if you don't have something to hold on to, obviously. Well, Freddie Gray couldn't hold on to anything. His hands were cuffed behind his back. If he crouched in the van, facing the front of the van, and the van stopped in a normal way for traffic or a stop sign or a red light, it would be likely that Freddie Gray would plummet forward, smash his head on the front metal bulkhead of that prison transport van, and suffer a shallow dive type of injury. That's almost certainly what happened to Freddie Gray. And no officer did that to him. Now, there may have been arguments about a week before Freddie Gray's arrest. There was a new rule policy promulgated through the Baltimore PD about seat belting suspects into these vans or into police vehicles generally. And basically the rule said, listen, we never had this requirement before, but now we're going to ask officers to seatbelt in suspects. But we're going to leave it to the officer's discretion, depending on safety, other considerations. To put a seatbelt on someone, you kind of have to extend your body across their body. Some suspects bite and spit. There may be other suspects already in the van. So they said, listen, we prefer, if it's possible to do it consistent with safety, that you buckle in the suspects, but we're not going to order you to do it. We're going to leave the final decision up to your discretion of the individual officer based on the totality of the circumstances. Well, they adopted that policy about a week before Freddie Gray's arrest, and they promulgated it mostly by email. And I guess during some early morning meetings of officers before they went out on the street. But they were never able to show in court that any of the 6 officers charged in this case had been actually informed of this change in policy. There was no evidence that they had been presented with this change of policy in their pre-brief meeting before going out on the street. There was no evidence that although this policy was emailed out, they actually called the IT expert for the Baltimore PD who testified, listen, our IT systems are so foobarred, we have no idea what emails go out or whether people receive them. There's no mechanism to acknowledge them. So there was no evidence that these officers even knew that this new policy existed. But even if they did know, it was still within their discretion to choose not to seatbelt a suspect. But even if all that was true, what we're talking about then is that at worst, an officer neglected to buckle in Freddie Gray. But that's not what these officers were charged with. These 6 officers were charged with crimes as serious as murder. Murder. I mean, they would have spent the rest of their lives in prison. Murder by failure to seatbelt, when we don't even know if the officer was aware of this, a policy, a discretionary policy just adopted days ago by the police department. For the Baltimore Police Department had been in existence for something like 140 years at this time. For 140 years, there was zero requirement to seatbelt in suspects. And now we're going to charge and prosecute and convict these officers of murder in these cases. Now, of course, when all this happened, the Baltimore PD conducted an investigation to determine what happened. Were any officers responsible for misconduct that led directly in a demonstrable, evidence-based way to Freddie Gray's injury? And this went on for some weeks. It was put under the charge of a female detective, a female Black detective. And she was just finishing up her report. It was about to be released within 24 hours. And her report was going to conclude that there was zero evidence that any of these officers involved in Freddie Gray's arrest had done anything wrong, had done anything to injure him at all. So the conclusion of the investigation was going to be that there was no basis for criminal charges against these officers. In fact, eventually, by the way, at the end of all this, the officers would also be subject to administrative review, where misconduct need not be proven beyond a reasonable doubt, as in a criminal court. The police department could just say, "Well, we don't like the way you did that, and you're fired." And none of them would be fired. I mean, they weren't even found to violate anything on an administrative level, much less a criminal level. But in any case, the Baltimore PD, this female Black detective, was finishing her report. It was going to find no grounds for charges against any of these officers. And it seems, I'm speculating now, of course, but it would appear that Marilyn Mosby, her office, got wind that this was going to be the conclusion of this political report. And Mosby likely had some concern about this because there had been a lot of propaganda in the media about how Freddie Gray was killed, broken neck, in police custody. Somebody must be held accountable. And there was a real risk that she might be held accountable, because it was she that requested the police sweep of the block in the first place at her husband's request to her, as you'll recall, we talked about before. So she couldn't let this go. She was politically vulnerable here. She had to deflect attention away from herself. So suddenly, hours before the Baltimore PD investigative report finding no basis for criminal charges against these officers, hours before that was released, Marilyn Mosby announced an outdoor press conference on the steps of the grand building in which she worked, on a big podium, high above all the reporters who were at the bottom of the steps. So the camera footage was great. And she announced a series of criminal charges, a whole bucket of criminal charges against these officers, including charges as serious as murder. And when asked about the basis for these charges, what's the factual basis? She said, well, the Baltimore PD, I'm not even paying attention to what they're doing because I had my office conduct its own independent investigation. This was the first time anybody had heard about this. It's true that the prosecutor's office had its own investigators. That's very common. Indeed, my first job in the legal circles was as an investigator for a public defender's office in upstate New York. That was my first exposure in a professional way to the law. Not as a sworn officer, folks. We weren't that. We were just investigators for the public defender's office. So it's very common for these officers to have their own investigators. She had them, and she said she had some of her people, her investigators, conduct their own independent inspection of what had happened, and they found factual grounds for these criminal charges. Now, later, after these trials all blew up in Mosby's face, her investigator, who supposedly did this secret parallel investigation, was put under oath and asked about his efforts in investigating this case. And he said, while under oath, I don't know what she's talking about. We didn't have any investigation. So the whole narrative by Mosby was a complete fabrication. She had no factual basis for any of these criminal charges at all. Unfortunately, in America today, we don't have real probable cause hearings. We have make-believe probable cause hearings. And if a prosecutor is willing to come into court before a judge, before a magistrate, and say, hey, we promise to show up eventually with evidence to support these criminal charges. We just want you to let us proceed to trial. The judge goes, yeah, okay, fine, we'll do that. You put it in front of a grand jury. Of course, a grand jury will indict a ham sandwich. The grand juries only ever hear from the prosecution side of the argument. They don't hear the defense side of the argument. And if you only hear one side of the argument, it always sounds compelling. So off to trial, these 6 officers would go. Now, then Marilyn Mosby began to run into some procedural hurdles that were very uncomfortable for her, very unfavorable for her. One is that the judge the trial judge in this case, Marilyn Mosby wanted all 6 officers to be tried in a single proceeding. And prosecutors like this approach because if you can find dirt on any one of the defendants, it tends to taint all the defendants, right? So it makes it easier to present a gestalt of guilt to the jury collectively, even though each defendant's criminal liability is supposed to be individual. If you can try them together, then if one guy has whatever, I'll make something up. This was not in evidence in this case, but if one guy had racist text messages on his phone, you can taint everybody else with that association, or at least make the effort to do that. So the prosecutor wanted all these cops to be tried in a single trial, and the defense objected, and the trial judge went with the defense. So every officer would get their own trial in front of the same judge. By the way, it was the same trial judge for every one of these 6 officers. Now, not all the officers ended up going to trial, as we'll talk about, but they would have been in front of the same judge. So that's important to remember. I see Mark West talking about how, Freddie Gray was, one of the allegations was he was killed by a rough ride. This was an allegation made in the media. It was part of the propaganda campaign. The amount of evidence presented by the prosecution, and there was video of this van throughout its entire route. So we know exactly what was happening in the van. The evidence of this van being used to subject Freddie Gray to a rough ride, zero. And Mark West, if you have such evidence, please share it with us. But I watched every minute of that trial, and there was no evidence of a rough ride presented. It was pure propaganda. It was lies, presumably put forth by Marilyn Mosby's office. And the fact that rough rides might happen in other cases is irrelevant to this case, right? These police officers are not responsible for what other cops might have done. So we have these 6 trials. They're going to be individual. They're not going to be collective. That's bad for Marilyn Mosby. The first cop goes on trial. He happened to be a black male officer, and it's a jury trial. And the jury hangs. It's a mistrial. So some of those jurors were convinced that that first officer had been proven guilty beyond a reasonable doubt in the death of Freddie Gray on those charges against him. But other jurors said, no, we're not convinced beyond a reasonable doubt, which would seem to be the prudent position because there actually was no evidence that that officer had used any force, any unlawful force against Freddie Gray, and certainly no force against his neck. And he was not the driver of the van. So to the extent Freddie Gray should have been seatbelted in, well, that was really the responsibility of the driver of the van, who also happened to be a black male cop. So hard to find any kind of racist motivation there for either of these men. But that first trial was a jury trial, hung jury, mistrial. And of course, the prosecution immediately announced, as they're privileged to do, well, don't worry, buddy, we're going to prosecute you again. We're circling back to you. So you're on notice because if it's a mistrial, the prosecution's free to prosecute you again. By the way, are you likely to have any resources for a second trial after your first trial? So if you're on trial for murder and you're looking at spending the rest of your life in prison without possibility of early release, what % of your resources are you prepared to spend to not have that outcome, to not be found guilty? Probably everything that you can beg, borrow, and steal, right? I mean, I would. It would seem a poor economic decision to shave away your legal defense budget if that increases your risk of spending the rest of your life in a cage with unpleasant people. But if you spend really all your resources on that first trial and you have a mistrial and they try you a second time, what resources do you think you have left? Because I can tell you in my experience, normally the defendants have none. I see many cases where there's mistrials and the defendant had very high-powered, expensive legal representation in their first trial and a public defender in their second trial because they had no money left for an expensive legal counsel again a second time around. And there's nothing wrong with public defenders, folks. Many public defenders I know are world-class attorneys, but they are all way overworked. You're just not, and they don't have anything like the resources that a highly paid private defense attorney would have. So we'd like to think we live in a world where the amount of resources you can bring to your legal defense doesn't affect the kind of outcome you get, the kind of justice you get, but we do live in that world. Frankly, that's one of the reasons that we are partnered with CCW Safe. In fact, I'm a member of CCW Safe. My wife, Emily, is a member of CCW Safe. They're a legal service membership, what many people mistakenly call self-defense insurance. And in effect, they promise to pay their members legal expenses if the member's involved in a use of force event. And those legal expenses get huge quickly, folks. If you're charged with murder, the cases I consult on, it's very common for the defendant to burn through $200,000 before they get to trial. And then it just goes up from there. So if you manage to have that money and spend that money, and of course, many people don't have that money stuffed in a mattress just in case they have to use a gun in self-defense. But even if you have it, you spend it all in the first trial, what's left for a mistrial? Nothing, unless you're a member of something like CCW Safe, particular CCW Safe, because they'll cover you again without limit on the retrial the second time around. So you're just as well resourced for the retrial as you were for the first trial. If you're convicted and you're appealing, they cover the appeal. If your conviction gets reversed on appeal, generally that means, again, you're not found not guilty by the appellate court. You're simply going back for a second trial, and CCW Safe covers that, again, without limitation, without a cap. So it's one of the many reasons I'm a huge fan of this organization, CCW Safe. We do a lot of partnering work with them. As I said, I'm a member myself, as is my wife. So it's the one plan I always encourage people to at least take a look at. Now, no plan is perfect for everybody. I'm not saying CCW Safe is perfect for you, but if you're interested in this kind of financial coverage, I would strongly encourage you to at least take a look at what they have to offer. And if you do that at lawofselfdefense.com/CCW Safe, you can save 10% off your membership with them using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCW Safe. So that first officer, hung jury, mistrial. Prosecution says, don't worry, we're coming back to you. We're going to try you again. But then Marilyn Mosby ran into another difficulty. And that is that in Maryland, a criminal defendant has an absolute right to demand a bench trial instead of a jury trial. And there's nothing a prosecutor can do about that. Now, what's the difference? In a jury trial, you have the trial judge, and then you have a jury. The judge is supposed to determine the law that applies, what law he will instruct the jury on, and the jury is the finder of fact. They determine what facts they believe to have been proven or disproven to whatever the required legal standard is over the course of the trial. So they determine the facts, the judge determines the law. Two separate jobs, two separate entities in the courtroom to do those two different jobs. When you have a bench trial, you don't have a jury. The judge plays both roles. The judge plays the role of the finder of law, as he always does, but he also assumes the role of the jury, the finder of fact role of the jury. And there's a cliche in legal circles that if you're guilty, you want a jury trial. And if you're innocent, you want a bench trial. And the rationale is that if you're guilty, and most criminal defendants are demonstrably guilty, that's why they're at trial. Prosecutors don't tend to bring hard to prove cases to trial. They tend to bring easy to prove cases to trial. If you're guilty, what you're hoping for is that your defense attorney can use emotion or rhetoric or distractive techniques, cries about injustice or something, some emotional appeal to at least one of those jurors, to keep at least one of those jurors from voting guilty, from finding that you've been proven guilty beyond a reasonable doubt. And then you end up with a hung jury. Now, preferably, you'd like to convince all 12 jurors not to vote guilty. But if you get at least one, well, that's a win for the defense. I mean, anything that's not a conviction is a win for the defense. It's not as good a win as an acquittal, but it's a win. So if you're guilty, you're hoping your defense attorney can convince at least one of those 12 jurors to not vote guilty. Then you get a hung jury, you get a mistrial. So if you're innocent, however, you're concerned about the prosecutor swaying the jury through emotional appeals. And let's face it, jurors they're certainly not legal experts. You never know what you're going to get in a jury. They're not technical legal experts like a judge is. So if you're innocent and the law and the facts are actually in your favor, you don't want to subject that to the emotional vagaries of an unpredictable jury. You want a legal technician to do that legal analysis, because the judge, in theory, he might be subject to political pressure as well. But in theory, the judge would act more like an algorithm, right? You would input the law and the facts. If they're clearly consistent with falling short of guilt beyond a reasonable doubt, that's what you would expect a legal technician like a judge to conclude. So if you're guilty, you'd like a jury. If you're innocent, you'd like a bench trial. In most states, however, you cannot demand a bench trial as the criminal defendant. The prosecution has to agree. So, for example, in the Kyle Rittenhouse case, Kyle did not have the option of demanding a bench trial. Prosecutor Binger would have had to agree to a bench trial, and he would never have agreed, given the state of the facts and law he had to work with. The only hope he had for a conviction was to bamboozle the jury completely. He proved unable to do that. But that was his only hope. So Binger was never going to give up his own privilege to have a jury, which is how most states look at it. The defendant has a right to a jury. The prosecution has a right to a jury. Either one of them can demand a jury trial. But in Maryland, that's not the case. In Maryland, the prosecution doesn't have a say in this. It's entirely up to the defendant. And this drove Marilyn Mosby crazy because, of course, she didn't have any facts that was consistent with guilt beyond a reasonable doubt for any of these officers. So her only hope for a conviction was an emotional appeal to the jury. And if there is no jury, there's no emotional appeal. Well, the first trial of the first officer, the male black officer, was a jury trial. mistrial, so he was going to be tried again. But the other officers waiting in line to be tried before the same trial judge, now having had a chance, by the way, to see the first trial judge in the first trial, get a sense for what his rulings were, for example, maybe a sense to see that the trial judge is not a politically motivated lunatic, decided, you know what? The second officer says, hey, time for my trial. I don't want a jury. I want this judge to be my finder of fact. And that's what happened. The second trial was a bench trial, and Marilyn Mosby screamed about it, but there was nothing she could do under Maryland law. Second trial was a bench trial. The judge heard all the evidence from the prosecution, heard, of course, everything from the defense, and acquitted that police officer. And then there was a second trial of yet another officer, and the same trial judge heard all the evidence, heard all the arguments, and acquitted that police officer. And if I recall correctly, there was still another trial, again a bench trial, in front of that same trial judge, and he heard all the evidence and all the argument, which, by the way, hadn't changed. The essential law and facts for all these cops were the same. I mean, it was just the arrest of Freddie Gray. So there was no real variance in the law or the facts for any of these cops. So in that third bench trial, same trial judge hears the law and argument, acquits that cop too. And at that point, I presume what happened was the judge basically looked at the prosecution and said, are we really going to do another 3 trials like this? Because nothing's going to change. The facts are not going to change. The law is not going to change. And my view of them are not going to change. It'll just be 3 circuses resulting in acquittals. And at that point, Marilyn Mosby gave up, dismissed the charges against the remaining officers. And that was the end for the state prosecution of those officers. They would also be investigated, of course, by the Department of Justice and the FBI for purported civil rights violations, which took a couple of years to happen. And ultimately, the Department of Justice concluded there was no grounds to bring federal charges against any of these officers. And they were investigated administratively by their department, and all of them were found to have engaged in no misconduct at all, none, and all were privileged to return to duty. I'm not sure all of them did. I think 1 or 2 of them might have taken the option to retire at that point, but they were all eligible to return. So that's where things were left with Marilyn Mosby. Now, when it was discovered after the fact that this purported secret second independent investigation that was supposed to have provided the factual basis for the criminal charges against the officers, when it was revealed that that investigation never actually happened, well, a bunch of these cops decided, well, that's bullshit. That's not a reasonable use of prosecutorial discretion, and they attempted to sue Marilyn Mosby in civil court. And in my opinion, they should have been permitted to do that. Lying about a fake secret second investigation is well beyond the normal bounds of prosecutorial discretion, and Marilyn Mosby should have been held accountable for that. She was not. Ultimately, the courts decided her qualified immunity protected her from these civil suits. So there was really at that point nothing more the officers could do. And I will point out, after all this, Marilyn Mosby was reelected a second time to that office, again with Soros-provided funding. And if you have enough money, you can get anybody elected. But she's still, of course, state's attorney in Baltimore to this day, and plans to run again a third time around. So that's the backstory to Marilyn Mosby. She tried to put 6 officers in prison on charges as serious as murder, meaning life in prison without possibility of early release, in a complete absence of evidence that any of these officers had done anything wrong. And she did that for political purposes, generally, and for personal advantage, because she perceived that she and her husband were at political risk if it was discovered that all of this had been initiated at her request, based upon her husband's request to her, something the media very rarely reported on. So now she finds herself federally indicted for having committed what appears to be pretty clear perjury on federal documents and looking at several decades of federal prison time herself. Now, I wouldn't wish bad things on people generally. Certainly, I wouldn't wish something like cancer on Marilyn Mosby. But if she did this to herself, and it's hard to understand how she didn't knowingly commit perjury on multiple documents, federal documents, for tremendous personal advantage, vacation homes in the $500,000 range. If she did this to herself, well, then she earned it. And given what she tried to do to those officers, it feels a lot like karma circling back around. All right, folks, I think that's all I have to say about the Mosby thing. Let me scroll through the comments here and see if there's anything I need to address. Again, if you'd like to submit questions about this case or any other matter, use of force matter, feel free to do that as a super chat, and I will be happy to answer your questions. And I got a little more practice today doing the screen sharing thing, which is good. And I guess I should remind everyone, whatever platform you're watching this in, probably YouTube, I'm supposed to ask that you hit the like button and the share thing and you subscribe. If you're commenting, I believe you're already subscribed. I think you have to subscribe to comment, but all of that helps us grow the law of self-defense community. So that's greatly appreciated. While I'm scrolling through the comments, let me pop up, as many of you will know, we have a couple of free things to offer you. One is our free infographic. This is a downloadable PDF, the 5 elements of self-defense. These are the building blocks of any claim of self-defense. If you don't understand these 5 elements, you simply can't understand how self-defense law works. This just lists those 5 elements, provides a brief, sentence or 2 description of each. It's the very basic, most fundamental information you have to have. We provide this infographic for free, folks. We don't charge a penny for it. It's just a PDF download. You can get that at lawofselfdefense.com/elements. If you happen to be an instructor and would like a poster size version of this infographic to hang in your classroom or whatever, we have those available too. We do charge for those, of course, because we have to print them and ship them. I don't think they're terribly expensive. But again, you can, if you're interested in a poster size version of the infographic, you can also get that at lawofselfdefense.com/elements. But just the PDF download that you can print yourself, you can print it for your students if you're an instructor. It's fine with us. You can get absolutely free at lawofselfdefense.com/elements. We also have our free book offer. This is our best-selling book, The Law of Self-Defense. You can buy it on Amazon. I think it's $25 plus shipping and handling. We'll make it available to you for free in terms of the cost of the book. We do ask that you still cover the cost of shipping the book to you. I think that's $7 or $8, something like that, maybe $8.95 shipping and handling. But we eat the $25 cost of the book. You can look it up on Amazon. There's something like 1,000 reviews. It's a solid 5-star rating, very well-reviewed book, and you can get it for free, but for the cost of shipping and handling at lawofselfdefense.com/free book. And then, of course, we also have our Law Self-Defense memberships where we have this kind of content times thousands of blog posts, videos, legal analysis. And when we do this kind of content in this open access way, we also provide it to our members, but buttressed with more content. So, for example, we'll have a transcript of this show available for our members. We'll have the federal indictment form embedded in the content for our members, links to other resources and stories, blog posts, videos, podcasts we've done on these and other related cases. Again, that's all available to our members. So it's kind of a supercharged version of the live show you're participating in right here. And the great thing about Law Self-Defense membership is, first of all, it's cheap. It's only about a quarter a day. It's less than $10 a month. And you can try it out for 2 weeks for just 99 cents. So 99 cents, you get unlimited access, just like any other member, to all of our thousands of blog posts, videos, podcasts. And if you don't like it within that 2-week period, just tell us and we'll give you back 200% of your money. So it's only 200% of 99 cents. I get it. It's not much of a refund, but we didn't ask for much up front. And if you like it, and virtually everyone does like it and stays a member, folks, then it just reverts to a standard membership at about a quarter a day, less than $10 a month. You don't have to do anything extra. It just automatically, you're a member of Law of Self-Defense. So that would be something you can consider. It's a negative risk opportunity, folks. You literally can't lose. So I would encourage you to take advantage of that at lawofselfdefense.com/trial. And I'll leave that up while I scroll through the comments here and see if there are any super chats that I need to address. Let's see. Yes, and I do have to connect with Nick so he can explain to me how he does his super chat stuff so much more efficiently than this tiresome scrolling through the comments that I'm obliged to engage in. He's promised to help me with that. I believe him. I just have to circle back and connect with him. Let's see. Oh, here's one. Thank you very much, BG Willa 21207. The best summary of the Freddie Gray riots, and I live here. My office closed that day and watched the proceedings on TV. Yes, always good advice. If you're at risk of finding yourself engaged in a riot or any other kind of physical violence event, the best way to make it through the other end of those things without harm is to not be there, is to be someplace else. Best way to win a fight, fist fight, knife fight, gunfight, is to be someplace else. Let's see. Evil Bunny, thank you very much for your very generous super chat. Evil Bunny is a super fan. Let's see. I do appreciate all the comments, folks. I can't, I'm not even given a list of how many comments there are. A count, I mean, but there are a ton of them. Debbie O, very generous super chat contribution. Thank you so much for your support, Debbie. She says, I'm loving your streams, Andrew. I hope you keep them going. We're trying our best. It's not our normal workflow, but every year we try to kind of shake the box a little bit, try different things. And these live streams are one of the things we're trying. It's a little challenging, to tell you the truth. One of the toughest parts for us actually is just the moderation. I mean, Emily, my wife Emily, is doing the moderation for these. But she actually has other responsibilities that she needs to be working on that I take her away from every time I ask her to moderate one of these. So we're exploring alternatives to having Emily do this kind of moderation. Let's see. Ittos, ITTOS 90. Very generous super chat, writes, really enjoy all your live appearances. Was just looking at the CCW Safe site and notice several states do not allow purchasing of these types of plans. What is the legal justification for this, if you know? Hold on just a moment. Oh, my camera's not on. Okay. Thank you. Thank you. Now I am back for answering the question. So let me get back to the comment from Itos90. Looks at the CCW Safe site. Notice several states do not allow purchasing of these types of quote unquote self-defense insurance plans. By the way, these companies are not insurance plans. They don't like to be called insurance plans. CCW Safe, as I had put up before, they call themselves a legal service membership. They don't provide insurance. They themselves are insured. They have an off-site, out of the country, self-owned insurance entity that provides the financial security for them to meet their obligations. But they're not selling you that insurance. That's insuring them against payments they would need to make on behalf of members. They're not providing insurance themselves. Well, what happens is it's just political, the decision by these states to outlaw these kinds of plans. And there's no constitutional basis in it. Prepaid legal services, which is basically what these plans are totally lawful. Now, what happens is the politicians get offended at this. And perhaps they're fearful that if people feel like they have this kind of coverage, they might be more aggressive about using deadly force in purported self-defense, and you'd have more dead people, and that would be a bad thing, according to the politicians. That's not been my experience working with otherwise law-abiding people, but nevertheless. And the politicians in a handful of states refer to these programs as basically murder insurance. And strictly speaking, you're not allowed to insure against actual criminal activity. So you can't buy insurance. Say you're a drug dealer. You're reasonably worried you might someday get caught and arrested and prosecuted for drug dealing. So you want to buy insurance to insure yourself against your legal defense costs should that happen. You're not allowed to do that. You're not allowed to buy insurance for intentionally unlawful conduct. Of course, the complicating issue in self-defense cases is that if your use of force, your shooting of that other person, it's contested whether it was unlawful. Sure, you shot him, he died, and that could be murder, or it could be lawful self-defense. And if it's lawful self-defense, it's not unlawful conduct for which you ought not be able to buy insurance. It's lawful conduct. Arguably, it's a social good. But politicians being politicians, especially in these hardcore anti-gun states like New York, Washington State, I think there's one other, but I forget now which one it is. They simply send letters to companies like CCW Safe and all the others, Armed Citizen Legal Defense Network, USCCA. They all get the same letter from, usually it's either the insurance entity within the state or the prosecutors within the state, who say, listen, if you continue to sell these plans in our state, we'll take you to court and we'll prosecute you, and we'll just use the legal process as a punishment. And none of these companies are big enough to fight a New York state. It's just not worth it to them. So they just agree to stop writing policies in those states because of the political pressure from those states. And then they don't have the means to like try to argue this up to the U.S. Supreme Court. They're just not going to do that. They're not going to distract from their core mission. So if you live in one of those states, you're out of luck for these kinds of coverage. I think in New York State you can actually still get CCW Safe, but only if you're a law enforcement officer. Otherwise, it's not available. There's nothing CCW Safe can do about that. It's not up to them. Believe me, they would love to be selling plans into New York State, into Washington State. It's just not cost effective for them to do it, given the political pushback from those states, the unconstitutional abuse of political power by those states. But that's the way it is. They're big bullies, but they have the power to make their bullying effective. If you've heard of our own Platinum Protection Program at Law of Self-Defense, that is permissible everywhere. We've never gotten a letter. All I really do is provide my legal services free to our Platinum members, and no one can tell me I can't work for free. But you do need to be a Platinum Protection member to get our consult services free. Now, all our Platinum program covers is my cost. It doesn't cover your legal expenses generally. So it doesn't do what CCW Safe does. It only covers me. In fact, this year, effective January 1st, 2022, the only people for whom we're providing legal consult services are our Platinum members. If you're not a Platinum Protection member at Law of Self-Defense, we're not available to do a legal consult. We don't have the bandwidth anymore. So if you're interested in being a Platinum member, you can learn more about that at lawofselfdefense.com/platinum. All right, let's see what else we have. More comments have rolled in while I was answering that. Kenosha County I. Oh, is that a podcast? Is that a blog site? It sounds familiar to me from Rittenhouse. They made a super chat, said, love your show. Thank you. Well, thank you for that support. We really appreciate it. No matter how small, it's always helpful. Even if not necessarily in a monetary sense, it's helpful because it affirms to us the level of interest for people to have us keep doing this. And probably you all know what the definition of burnout is. Burnout is when the juice doesn't appear to be worth the squeeze, when you're putting effort into something and there doesn't seem to be an adequate return on investment. And that return doesn't necessarily have to be monetary. It can be, emotional, job satisfaction. I'm happy to do this kind of stuff as long as people are actively engaged. So to the extent we get even modest support in the form of super chats, that affirms our commitment to doing these kinds of live streams. Let's see. Scroll. Again, I'm sorry, folks. I can really only answer the super chats. And I see people asking about in the normal comments about the alternatives to CCW Safe. There are other companies that offer similar services. Armed Citizen Legal Defense Network is one that I think the world of. My only and by the way, they're great people. Marty Hayes, Gila Hayes. Their board is fantastic. It's Masada Ayub, it's Tom Givens, it's Dennis Tueller, it's John Farnham. I mean, these are giants in the self-defense community. So I think the world of Armed Citizen Legal Defense Network. I do personally prefer for myself CCW Safe because of the much greater financial resources that CCW Safe has to bring on behalf of its members compared to Armed Citizen Legal Defense Network. That's not a criticism of Armed Citizen Legal Defense Network. And between the two of those, you may well find that ACLDN is the better fit for you, in which case I would encourage you to go with them. There are also other companies, USCCA. I cannot recommend USCCA because of how they've conducted themselves in some of their member cases. I'm not going to dive into detail on that now, but I've blogged on it and did videos and podcasts on it extensively. You can access my views on USCCA and how it's how it's dealt with some of its members at lawofselfdefense.com/USCCA. Lots of content there. In fact, I'll put that in the comments. I'll call it USCCA coverage, lawofselfdefense.com, USCCA. We'll get you to our prior blog posts and such. Some of the programs I really just, of course, there used to be the NRA Carry Guard program that thankfully is now defunct. It was a terrible program, if only because, and I say that as an NRA Life benefactor member. I've been an NRA Life member really my entire adult life. But that Carry Guard program was nonsense. It was a reimbursement program, 99% reimbursement program, meaning they would reimburse your legal expenses if you were acquitted, which is ridiculous because you need those resources to fight the legal battle in the first place. By telling you you'll be reimbursed afterwards, they're compelling you to fight the legal battle without resources, which means you're actually more likely to get convicted, which means then they don't have to reimburse you. The entire thing was a train wreck. So certainly I don't miss it being gone. There's also the various legal shield programs. Not a fan of those. I don't like the way they're structured. I don't like the way you're bound to use only one of their recommended attorneys. One of their attorneys join that program. And you have to choose one of the attorneys that's a member of that program because of the way they capitate their attorney fees and so forth. I don't want someone else picking my attorney for me if the rest of my life is at stake. So I'm not a fan of the shield programs. I've spoken to the people there. They seem very nice, genuinely intentioned people. I don't believe I'm not trying to suggest by any means that they're looking to rip people off. And there are some programs out there that do look that way. I wouldn't say that about the shield programs. I think there are better alternatives out there, and I don't like the way they're structured personally and professionally. Let's see. Oh, someone asked about Texas. I am planning to come to Texas shortly. I just was able to finalize my travel dates with my lovely bride. She's going to cut me loose for a week to ride my motorcycle through Texas Hill Country. So I'll be going from Denver to Amarillo and then spending about a week in Junction, Texas. 5 days in Junction, Texas, riding around Texas Hill Country. Probably, it looks like that last full week of February. The dates are a little iffy because, of course, I am in Colorado in the winter. So if there's a snowstorm right around the time I need to leave, I might need to leave a couple days earlier, a couple days later. So it's a little bit fluid. I don't mind the cold weather, but riding a motorcycle through snow is probably not the best idea. Usually the snow doesn't stay very long on the roads here out of the mountains of Colorado. So I don't expect it to be much of an issue, but it may affect the timing. But I will be riding around Texas Hill Country based out of Junction, Texas, sometime around that last full week of February. So very, very much looking forward to it. If any of you are in that area and you'd like to meet up for coffee or something like that, feel free. I will be blogging and doing live streams and such, even on that trip. So I do a lot of motorcycle trips and I do a lot of work. So we actually have a little studio in a box, like a Pelican case that I carry with me on the bike. I get to my hotel, set it up. It's not quite as fancy as my setup in the office, but it's pretty darn good. So you should expect ongoing content from me during that trip. Maybe some photos and video of the trip itself. If you're into that, we'll have to see how that goes. But work will continue. What I tend to do on those trips is, put in an hour or two of work early in the morning. Usually that'll be like a live stream or a blog post or a podcast, something along those lines, and then spend the rest of the day riding the motorcycle around. So that's our plan for that trip. Only $99.99 for the coffee, folks. Now, if you want to meet up for coffee and I can fit it into the itinerary, there's obviously no cost for that. If you have my books or anything like that you'd like me to sign, bring them with you. I'd be happy to sign them. Let's see. All right. I think I've gotten through all the super chats at that point. Oh, here's one from Adonis King. Thank you very much for the support. I'm from Venezuela since 1999. My parents say this country can never turn to Venezuela. States too many freedom-loving Americans that are smart. Well, I certainly hope we don't become Venezuela. Venezuela was itself a very different country not that long ago. But here we are. I see Emily is Contrarian 420. Thank you very much for your super chat. Says, cheers, Andrew. Appreciate your voice and stances. That's very kind of you. Much appreciated. Let's see what else we have. I'm just looking for the colors here, folks. Let's see. All right, back down to the bottom. Yeah, this is really unwieldy for sure. All right. Emily is right outside of my door. Let me see if she's trying to get my attention for something. Hold on. Okay, she just emailed me. She emailed me a list of the super chats. Let's see, make sure I didn't miss any. Nope, looks like I got them all. All right, folks. So in that case, out of respect for your time and mine, we've been going for about an hour and a quarter. I will wrap this up. As always, we're trying to do more of these live streams. If we can do them every day, I'll do that. We're kind of exploring options for new workflows for this new year of 2022. Delivering, we try to deliver a little more value every single year by being a bit smarter about how we deliver content. So our goal is to do more of these. If we can do them every day, we will, probably in the morning like this, so we don't step on other well-established live streams like Nick's, for example. So that should be the expectation moving forward. We'll see what happens. In the meantime, until we meet again, remember, if you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill. So my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so that you're hard to convict, not by legal tricks, but by knowing what the law of self-defense actually is. All right, folks, until next time, I remain attorney Andrew Branca for Law of Self-Defense. Stay safe.